Welcome back to the deep dive. We're here to cut through the noise and get you the essentials fast.
Making complex stuff hopefully a bit clearer, and maybe even a little less dry than reading the manual itself.
Exactly. And today we are definitely diving into the manual, the MPP, the Manual of Patent Examining Procedure. This is part of our ongoing series trying to make it more, well, digestible.
Especially if you're maybe studying for the patent bar or you just need a better grasp on U.S. patent practice day to day.
Today's target is Chapter 1800. That's the big one on the Patent Cooperation Treaty, the PCT.
And within that, we're drilling down into a very specific section, MPP 1807. It's titled Agent or Common Representative and General Power of Attorney.
Okay, let's unpack this then. When you file one of these international applications, someone's got to speak for you, right? Who gets to do that? This section, 1807, it basically lays out the rules for representation during that whole international phase.
Yeah, it's really fundamental to make sure everyone involved, the different patent offices, the authorities knows who's actually authorized to act for the applicant, who can make decisions, who gets the mail, that sort of thing.
So first things first, according to MPP 1807, who can actually represent you when you're dealing with the PCT international phase? What are the main choices?
Well, there are a couple of main avenues. For U.S. applicants, probably the most typical route is using a U.S. registered patent attorney or a U.S. registered patent agent.
Okay, so the folks officially recognized by the USPTO makes sense.
Exactly. They've passed the bar, they're registered to practice.
But what if you've got, say, multiple inventors on an application, or maybe a couple of companies filing together?
Ah, good point. If you have more than one applicant listed on the PCT application, you've got another option. You can formally pick one of those applicants. Could be an inventor, could be one of the companies to be the common representative.
So, like, designating one person from the group to handle things for everyone.
Precisely. They then act on behalf of all the applicants named in the application.
All right, so you can hire a pro, or you can pick someone from your team if it's a joint application. But what happens if you don't do either? Let's say you have multiple applicants and you just file. No formal appointment? Is there a default?
Yes, the rules anticipate that. The MPP has a default built in. If there are multiple applicants and nobody's formally appointed, no attorney, no agent, no common representative designated, then the system looks at the list of applicants. And the first applicant named on that list, who is actually eligible to file at the U.S. Receiving Office, is automatically considered or deemed to be the common representative.
Huh. So the order matters a lot, actually. If you list yourselves in a certain order, the first eligible person on that list gets the job by default if you haven't specified otherwise.
Exactly. It's a fallback rule. But it means you really should think about who's listed first if you're not making a formal appointment, because that person might end up being the point of contact.
Yeah, that seems like a potential, gotcha, if you're not paying attention. Better to be deliberate about it.
Absolutely. Making that formal appointment just makes everything clearer.
Okay, so let's talk about how you make that formal appointment. What's the actual paperwork involved? How do you tell the PCT system, okay, this is our person?
There are essentially two main ways to get it done, whether you're appointing an attorney, an agent, or that common representative we talked about.
What's method number one?
The first way is often the easiest if you know from the start. You can include the appointment details directly in the official PCT forms themselves.
Like in the main application form?
Right. Either in the request form, that's the initial filing form, or later on, if you enter the next phase, in the demand form for international preliminary examination. You just put the representative's info there and the applicant signs it.
Okay, so build it right into the application itself. Seems straightforward. What's the other way?
The other way is to submit a completely separate document, a specific power of attorney.
Like a standalone POA document.
Exactly. It explicitly states who is being appointed and what powers they have.
Now, you mentioned something earlier about where you send things. Does that apply here? Where does this separate power of attorney need to go?
Yes, and this is a really important procedural point. You can't just send it anywhere. It must be submitted to the appropriate PCT office or authority for the stage of the process where you need that representation.
Oh, okay. Can you give that example again? Because it might not be the office you originally filed with, right?
Correct. The source uses the example of needing representation before the International Preliminary Examining Authority, the IPEA. That's the authority that does a more in-depth examination later on, if you request it.
Right.
If you need your representative to act before the IPEA, the power of attorney authorizing them has to be submitted directly to that IPEA. Sending it just to the receiving office where you first filed might not be enough for that later stage.
Okay. So you need to make sure the authority that's actually doing the work at that moment has the POA on file. It ensures they know who they can talk to and take instructions from.
Precisely. It maintains that procedural clarity throughout the international phase. Different authorities might handle different parts of the process.
Makes sense. Okay, so we know who can represent and how to appoint them. Now, MPEP 1807 also talks about different types of power of attorney, right? Individual versus general.
That's correct. This offers some useful flexibility.
So an individual power of attorney, I'm guessing that's just for one specific application.
Generally, yes. It's tied to one particular international application identified in the document. The power granted is usually limited just to that single file.
Okay. And the general power of attorney. Now, this sounds interesting, like it could be a real shortcut.
It definitely can be, especially for applicants who file frequently. A general power of attorney, or GPA, is broader. It allows an agent or attorney to represent an applicant in potentially any international application the applicant files.
Any application. So current ones, future ones, one document could cover the lot.
Potentially, yes. That's the idea. Efficiency. But there are conditions, of course.
Always conditions. What are they?
Well, the general power of attorney itself has to be properly filed or deposited with the relevant office first. For U.S. applicants, that would typically be the USPTO acting as the receiving office. It needs to be on file before you try to use it for a specific application.
Okay, so pre-file the general power. Then what?
Then, for each new international application where you want that general power to apply, you have to specifically refer to it in the application papers. You basically say, hey, we've already filed a general POA, here's the reference number or identifying info. And there's a helpful clarification in the MPP about this. If you've already deposited that general POA with the U.S. receiving office,
Yeah.
when you file a new PCT application later, you don't necessarily need to file the original signed general POA all over again.
Oh. So what do you do?
You reference the previously filed general POA, as we said, and you typically need to submit a copy of that original general POA along with your new application documents.
Just a copy. Wait, does the copy need to be signed again or anything?
Nope, that's the key point. The copy itself doesn't require a new signature. The authority comes from the originally filed, properly executed general POA that's already on deposit, providing the reference and the copy links the existing authority to the new filing.
Wow. Okay. That is a significant convenience. Referencing plus copy, done. Saves a bit of hassle each time.
It really does streamline things for regular filers.
All right, so general powers sound pretty useful, but are there times when maybe the authorities say, no, we need something more specific here, or maybe they waive the need for a POA altogether sometimes?
Yes, both things happen. There's a general principle of waiver, but also a really critical exception to that waiver.
Let's start with the waiver. What gets waived?
Okay, so the USPTO and other PCT authorities, they can generally waive the requirement for having a separate power of attorney, or even relying on a general one, for many routine procedural acts. They do this to keep things moving, not get bogged down in paperwork for every minor action.
So, for day-to-day stuff, they might just accept instructions from the listed representative without demanding to see the POA every single time.
Sort of, yes.
Yeah.
There's some flexibility, but, and this is the crucial part,
The big but I was waiting for.
the big but. This flexibility, this waiver, absolutely does not apply to certain very specific, very significant actions. These are the withdrawal actions that fall under PCT Rule 90B.
Withdrawal actions,
Well,
like killing the applicant.
Exactly. It covers things like formally withdrawing the entire international application
Okay.
or withdrawing specific designations. That means deciding you no longer want to pursue the patent in certain countries you initially selected in the application.
So actions that basically reduce or eliminate the scope or existence of the application?
Precisely. For those actions, the MPEP is crystal clear. You cannot rely on any general waiver. A valid power of attorney, either specific or general, that explicitly authorizes the representative to perform such withdrawals must be properly on file and recorded.
Okay, that raises the question, why the strictness here? Why can't they waive the POA requirement for withdrawals too?
It really boils down to safeguards. Withdrawing an application or designations is a major step. It can mean giving up potentially valuable patent rights across multiple countries. It's irreversible, usually.
Right, you can't just easily undo it.
Exactly. So the system needs absolute certainty that the person instructing this withdrawal has the explicit, documented authority directly from the applicant to do so. It prevents accidental loss of rights or unauthorized actions. It's about protecting the applicant's core interests when the stakes are highest.
That makes a lot of sense. You need undeniable proof of authority before you let someone pull the plug.
Formal power for formal abandonment, essentially.
Got it. Power on file for withdrawals. No exceptions. Okay, any other potential traps or things that people might get wrong, especially if they're more used to, say, just filing regular U.S. patents?
Yes, there's one more big one highlighted in this section that often tricks people up.
Lay it on us.
It involves the customer number practice.
Ah, customer numbers. Yeah, in U.S. national practice, those are super handy. You link your address and all your firm's attorneys to one number, put that number on the form, and you're good to go for correspondence and representation.
Exactly.
Yeah.
It's very efficient for domestic filings within the USPTO system. But,
Here comes another but.
you guessed it, MPEP 1807 states very clearly, for the international phase of a PCT application, you cannot use the customer number practice for appointing a representative or designating the correspondence address.
Wait, not at all. Even if you're filing with the USPTO as the receiving office.
Not for those specific purposes during the international phase. If you try to just put your customer number on the PCT form, thinking it covers representation or the correspondence address,
Yeah, what happens?
the USPTO, acting as a PCT authority, will basically ignore it for those purposes. They'll treat it as if no representative was appointed or no correspondence address was provided via that method.
Wow. Okay, so that could cause major problems. Communications going to the wrong place, or the system thinking you don't even have an agent or attorney listed.
Absolutely.
Ah.
It means, bottom line, even if you live by your customer number for U.S. national applications, you must revert to the formal PCT methods for representation in the international phase.
So you have to either include the agent attorney info directly in the request or demand form, or file that separate power of attorney we talked about. No shortcuts using the customer number here.
Correct. Trying to use the customer number is effectively an error for these purposes in PCT, and you need to fix it properly according to PCT rules, which could cause delays if you don't catch it.
That is a critical distinction, a real heads up for anyone moving between domestic and international filings. It really shows why you need to know these specific PCT rules.
Definitely. The international system has its own logic sometimes.
Okay, let's try and summarize the key takeaways from MPP 1807 then. This section is all about making sure representation is handled correctly for PCT international applications.
Right. It tells you who can represent you, a registered U.S. practitioner, or a designated common representative from among the applicants. And don't forget that default rule. The first listed eligible applicant becomes the rep if you don't appoint one.
It also spells out how to make the appointment. Either put it right in the PCT request or demand form, or file a separate power of attorney. And crucially, send that POA to the right authority for the right phase.
We touched on the flexibility of general powers of attorney deposit once, then reference it with a copy for future filings. Very convenient.
That convenience hits a wall when it comes to withdrawals under Rule 90 base. Withdrawing the application, withdrawing designations, those need explicit, undeniable power of attorney on file. No waivers apply there.
And the final big warning. Forget about using your USPTO customer number to handle representation or the correspondence address in the PCT international phase. It doesn't work for that. You need the formal appointment methods.
So understanding these rules isn't just about bureaucratic hurdles. It's fundamental to making sure your application moves forward smoothly, communications get to the right person, and importantly, that critical actions are properly authorized. It's about using the system right.
Getting these formalities correct from the start can save you a world of trouble later in the international process.
Feels like we've got a much better handle on MPP Section 1807 now. Thanks for breaking that down.
My pleasure. And definitely want to give a shout out to Mike Shepard, the creative director behind this whole MPP audio series.
Yes, absolutely. And just our standard reminder for everyone listening, this summary was put together with the help of AI tools like ChatGPT and NotebookLM, so it might have errors or leave things out. It's really for educational info, only it's not legal advice.
Definitely not. For the official word, you always need to check the actual MPP text, talk to a qualified instructor, or consult a registered patent practitioner.
Right. So here's a final thought to chew on. Even in this system that tries to be globally streamlined, think about using just a copy of a general POA. There are still these hard stops, these points where strict formality kicks back in, especially around ending things like withdrawals.
Yeah, it makes you think, what does that tell us about the balance the patent system tries to strike? between efficiency and the absolute need for accountability and safeguarding core rights,
Yeah.
especially when it comes to potentially closing the door on an invention internationally.
Okay, got something to ponder. We'll catch you on the next deep dive.